Well, good morning. For those of you who are watching us live, for those of you who are watching us in person, and for those of you who are listening and watching to this recording, my name is Seth Stander, and I am the Community Aging Specialist for HHCI CARES, a part of the Hope and Healing Center and Institute. CARES, by the way, is an acronym that stands for Caregiving, Aging, Resilience, Ethics, and Spirituality. HHCI CARES is directed by Dr. Peggy Dettermeyer. Now, today, during the second of our 4 Aging with Grace sessions, I will be focusing on legal considerations. Last week, healthcare rights and responsibilities were covered, and in upcoming weeks, I'll address understanding living options and paying for aging. Each session, as you heard me mention or allude to at least before, is being recorded, and the recordings and the slides are going to be made available to all participants, and that's for all 4 sessions. If you have registered for all 4, terrific. If you've only registered for 1, good news, you're getting as a bonus all 4 sessions. You're free to go ahead and click on those links and attach slides if you wish, but that'll be after the conclusion of the series in a couple more weeks. We are here ideally to serve our growing aging population and ideally to serve the growing population of caregivers who are attending to older adults in need. So in addition to community education such as this, Peggy and I offer consulting with some special emphases on the hopes and challenges of aging, various issues related to bioethics, the hopes and challenges of caregiving, and navigating the journey of grief. HHCI, the Hope and Healing Center and Institute, is a nonprofit which is located on the campus of St. Martin's Episcopal Church here in Houston and is dedicated to meeting the psychosocial and emotional needs of the entire community. Thanks to some very generous underwriting, HHCI is grateful to offer our programming to anyone free of charge. With that, let's go ahead and begin with a necessary disclaimer that this session is an overview of legal estate options in the state of Texas. You will certainly want to consult an estate attorney for specifics related to your own issues and to your own location, whether you are here in Texas or elsewhere in the United States, or for that matter, in parts of North America or overseas. So we're going to start with the question of, do you have a will or a trust? And we'll focus on the concept of the trust a little later on in this presentation. But let's just answer the question first. Do you have a will? If you do, yes, that's great. We encourage you to review it periodically and to make sure that it is up to date when it comes to the specifics that you have placed within that particular document and accompanying documents. And we'll talk about what generally is in a will in just a slide or two. Now, if you don't have a will, well, no worries is kind of the way I would phrase it, with a little bit of a question mark. The state of Texas has written one for you. And again, if you reside in another state or territory or country, it's possible that the same has been provided to you as well if you have no will on record. And you'll notice I put in parentheses, yay. It's good that it exists, but again, the question here is one of, is it going to match up with your preferences when it comes to your final wishes about your personal possessions? So, like other states, the Texas Estates Code will lay out how your property will be distributed if you die intestate. That's the official term for dying without a will on record. And the next couple of slides will give you a sense as to how, at least here in Texas, an attempt has been made to fairly distribute your possessions if you die intestate. And it depends on who is identified as your surviving heirs. So, a couple of slides with regard to intestate distribution. Some of these, the first four categories, you can see on here. And again, you'll have the slides after the series to look at these in greater detail. But if you're assuming that your only survivor is a spouse, or your only survivors are children, or your only survivors are parents, or your only survivors are siblings, then you can see that the state of Texas has made it pretty straightforward. Everything that is in your estate will devolve to them. Obviously, debts need to be cleared, accounts need to be closed, properties may need to be liquidated, or they may be handed over in whole. Those are details that go well beyond a general conversation about intestate distribution. But the simple answer is, without a will, if these four categories of loved ones are the only categories of survivors, then they receive everything that is yours. You can begin to see in the next few categories, and this will continue into the next slide, how the state has attempted to go ahead and to fairly distribute based on who they identify as surviving heirs. And let's take a look just to see how they've made this distinction. When you go to the category of having a surviving spouse and having children of that spouse also in living and able to inherit, you'll see how the spouse, because it's a community property state here in Texas, will go ahead and retain a third of the separate personal property, and they'll retain the right to use the real estate that you've left behind. And this primarily means one's residence. If we're getting into more complex areas where multiple properties are owned, it is possible, but unlikely, that you as an individual, if you are a multiple property owner, are intestate. So usually we're talking about just one's primary residence. And then the children are entitled to everything else that the spouse category doesn't cover. Now, if you have a surviving spouse and children who are not children of that spouse, we see second marriages, blended marriages all the time in modern society, then you can see how the distribution changes. Half of the community property is split between the spouse and the children who are not children of that spouse. And then the same rules apply in terms of 1/3 of the separate personal property for the spouse, the right to use the real estate, and everything else going to the children. Again, the state is trying to distribute as equitably as possible without knowing what you, the deceased, would actually want to see occur. They're just trying to be fair in the absence of any documents that suggest how distribution would preferably occur. And you can see how this continues when it comes to a surviving spouse and surviving parents. The spouse would have all community property and separate personal property that they've brought into the marriage, and half of any separate real estate. And the parents would inherit everything else. One parent and siblings, but no spouse, Then you're going ahead and seeing a division of half of the separate property going to the parents, and the siblings will share the remaining half of the separate property that was once yours. Spouse and siblings as survivors. All community and separate property, half of the separate real estate belongs to the spouse, and everything else belongs to the siblings. So this may be in sync with what you would want to see in terms of distribution, but it really does make sense if you haven't considered creating and updating a will over time to consider doing so. And in an explanation of why, let's go back to basics and talk about the purpose of a will in the first place. First and foremost, to distribute your property to your chosen recipients, people or organizations. Now, obviously, we've mentioned in the intestate distribution slides different categories of family and loved ones. Spouses and children can certainly have their needs met per your wishes in your own created will. Other relatives can as well. Non-relatives, there may be people who you share deep bonds with through friendship over the decades. There may be charitable organizations that you wish to see part or all of your estate headed towards after your death. The point is that it should be ideally your choice and not the state guessing as to what type of distribution of your worldly goods should occur. Another would be, if you have minor children, naming guardians for them. Now, if your surviving spouse has children with you, obviously there's less of an issue there. Wills are contingency plans. So if you are planning on going ahead and distributing your property, you should name guardians for your minor children in the off chance that your surviving spouse, the other parent of your minor children, is not surviving at the time that you die. So we're talking about potentially other relatives, or if the last thing you want is to have other relatives have the responsibility for guardianship of your minor children, to have dear friends take on that role. Whatever your choice is going to be honored in a legally binding will. You can plan for estate taxes. Now, here, if your estate is over $12.06 million, $24.12 million for married couples, estate taxes come into play per federal law. These numbers are going to evolve as the years pass and as the federal tax code and as state codes change and evolve over time. If you are not a multimillionaire, you don't have to worry about this. But again, if you find yourself on that trajectory, you are going to want to plan for the estate taxes and the impact it will have on what you pass along to your designated heirs. And ultimately, you're going to want to name an executor or an executrix to manage your estate, to take on the responsibility of closing down your various financial and property and real world details, determining what should be distributed as is and what should be liquidated, and the proceeds be distributed per your wishes. And that executor or executrix is legally bound to follow those wishes as directed in the will, and also serves as the primary interpreter of those wishes. So let's talk for a moment about the requirements for a will. First and foremost, you're going to need to have a reason to occupy a particular status or relationship with another. to engage in a particular undertaking or transaction with another. This is what is known as legal capacity. And we can break that down into straightforward terms. If you are married, then you enjoy a status and relationship, legal and loving, ideally, with that spouse. If you have a business partner, you therefore have gone ahead and engaged in a particular undertaking or transaction. So depending on your particular affairs and whether they are entangled already with relationships, business, familial, charitable, you name it, that's where ultimately we need to demonstrate that your will, it needs to be written in the first place. Beyond that, though, is what is called testamentary capacity. In other words, the legal and mental ability to make or alter a valid will. This is the whole sound mind and body clause that you may have heard at some point in your life. The whole popularization of that is actually a good thing. To be of sound body and mind means that you possess the testamentary capacity to enter into a marriage, to enter into a business relationship, to enter into a donor relationship, which is the legal capacity piece as well. So what we're talking about is if you find yourself competent, if you find yourself able to go ahead and to make agreements, and if you find yourself with assets that are yours to control, the distribution of them, so long as you demonstrate the ability to function in regular society without impediment, then you are able to draft and alter a will. There is also testamentary intent, the disposition of your property in contemplation of death. This is a fancy way of saying you recognize that one day you will die, and that the things that you own can't go with you, and therefore need to be properly distributed as your wishes deem fit. Now, some formalities that go along with this. An attested will is one which, in writing, signed by you or another person at your direction and in your presence, and attested in your presence by at least 2 credible witnesses over the age of 14 who will never benefit from your will. That is one example of a valid will. And you will find that that is the most common form of wills that you are going to create with the assistance of legal tools, with an attorney. Whatever you choose to do, I recommend an estate's attorney, but again, it's your decision so long as you have capacity to decide whether you want to utilize a legal service you find online that walks you through the process. If you wish to go ahead and work with a clinic as opposed to an individual attorney, whatever the case may be, you're going to need to be able to sign it, or to go ahead and to have people attest that you have directed someone else to sign on your behalf. The impediments that I referred to earlier are not necessarily physical impediments. One can have diminished physical capacity due to a congenital a condition, or the results of a neurological disorder, or the results of an accident, whatever the case may be, and still very much be of sound mind and have the ability to go ahead and to say, these are my wishes. So ultimately, you want this witnessed, and you also want, and this is why I recommend settling this with an estate's attorney rather than trying to do it on your own, unless you are already familiar with legal software or working with clinics and so forth. Because in addition to having a will created and attested to, you also want to have a self-proving affidavit in place, which affirms that the will was properly signed, whether it was signed by you or whether it was signed, witnessed by folks who won't benefit from your will at your direction by someone else in your presence. You want that self-proving affidavit to be completed at the same time you complete that will, because that eliminates the need for those witnesses for whom years or decades may pass to be at a probate proceeding and to affirm that they saw a credible signing occur, whether it was your own signature or another person at your direction. This will save you enormous amounts of time if you are the executor or executrix of the estate. Now, there is, of course, and this has been made famous in movies and television as well, the category of will known as a holographic will, including addenda to an existing will. This can certainly be done, but it has to, from start to finish, be written in your own handwriting and be signed by you. Ultimately, if it cannot be written completely in your own handwriting and signed by you, it will not be considered valid, and it will certainly not supersede any previous wills that may already be in place. So you always have this option, but it's also, like anything else, best to consult with an estate's attorney as to why you would want a holographic will in place as opposed to one that is drafted for you and then signed and witnessed. So let's talk about probate. And we'll focus in particular on probate in the state of Texas. Again, your mileage may vary depending on where you live outside of Texas, if you are watching us live or watching this recording. The probate process is primarily to recognize that a person has truly died. That's why I have death certificates starred in this bullet point. And once that proof has been brought forward to wind up the estate so that asset distribution can occur, that means identifying everything that is in the estate, gathering all of the assets that are in that estate, and paying out all the debts that the estate is subject to. There are multiple items that are not subject to probate, and this is important for a few different reasons. Insurance policies with named beneficiaries, bank accounts with named beneficiaries, retirement accounts with named beneficiaries, property and assets that are held in what is called joint tenancy with rights of survivorship, and ultimately trust assets. We're coming closer to the section on trusts. None of these are subject to the probate process, which requires independent administration and ultimately is a matter of public record. So not only for the sake of expediency, but also for the sake of privacy, putting items outside of the probate process may be desirable for you. Some of these are very standard. The insurance policies, the bank accounts, the retirement accounts, the property assets, the trust assets can all easily be placed outside the probate process. All you have to do is name a beneficiary in the case of the first three, and in the case of joint tenancy with rights of survivorship, the other owner of the property and assets will automatically receive full ownership of those assets under joint tenancy with rights of survivorship. Now, It is important to note that here in Texas, you don't need court permission before taking steps to settle the estate, and you don't need to produce a bond for an executor or an executrix. So just keep those details in mind as you are going through in your mind when you prepare for your death and for the winding up of your estate, what the upfront costs may be to do so. And with that in mind, we'll move to the issues of trusts, and in particular, why a revocable living trust may be something for you to consider. A revocable living trust is a legal formulation that allows you to use your assets during your lifetime and securely transfer them to your beneficiaries after your death. You can name a trustee, whether it's you, your spouse, to manage this trust during your lifetime, during their lifetime. And the terms of this trust, a revocable trust, is one that can be changed whenever you wish. There are irrevocable trusts that very much have value in the legal world. We're not going to cover those today, and I would encourage you to go ahead and to educate yourself about them with an attorney as you go ahead and consider your estate, whether it makes sense to place any of your assets into an irrevocable trust. But when we're talking about smoothing the transfer of your assets from, say, one spouse to another, or from parent to child, sibling to sibling, whatever the issue may be, it's the revocable living trust that we recommend you pay attention to. It avoids probate. As the previous slide indicated, it's one of those categories, along with insurance policies with named beneficiaries, bank accounts or retirement accounts with named beneficiaries, where you can keep this information out of the public record, and like the property and assets that are held in joint tenancy with rights of survivorship, the trust will automatically and securely transfer to your beneficiaries after your death, making a probate process unnecessary. It avoids a conservatorship proceeding. If at some point after the trust has been created, you are incapacitated. And again, I'm not just talking about physical incapacitation or even the inability to communicate verbally, because we can find ways to go ahead and to have your wishes properly communicated, whether it's through typing them, whether it's through sign language, whether it's through other tools that are at our disposal. Ultimately, we're talking about a mental incapacity, whether that is due to a brain injury, whether that is due to Alzheimer's or other related dementia, reaching a stage where you no longer are considered on a medical or a legal level capable of adjusting any of your legal documentation. Now, I will point out that if you are trying to go ahead and to make yourself eligible for Medicaid or to avoid creditors, this is not the process that will make that happen. Ultimately, it's best to talk with your creditors. We talked about this actually in our first session in the case of the responsibility when it comes to healthcare rights and responsibilities to pay your medical bill. But we also talked about the right that you have to see an itemized bill and to negotiate a price. So with that in mind, I would encourage you to negotiate with your creditors at any time to make sure that they understand what you are capable of paying, because they would prefer to see partial payment rather than none at all. Now, as far as protecting assets from Medicaid, this primarily has to do with an area we'll cover in the last two of our sessions of Aging with Grace. And this is where, if you end up finding yourself in need of the services of a long-term care facility, in particular, a nursing facility with Medicaid beds available. And after a financial spend down period, you become medically and financially eligible to apply for Medicaid benefits, which, coupled with your monthly applied income, would cover your monthly stay in a nursing facility for the rest of your days. We will talk a lot more about that in the next coming sessions. So let's stick a pin in that for later on. But putting your assets into a revocable living trust is not going to go ahead and prevent you from having to go through a spend down period in order to become eligible for Medicaid. So something to keep in mind as you're planning for the future. So a revocable living trust does require the transfer of assets into trust, which is to say, you can't just create a shell. And frankly, you wouldn't want to. Ultimately, you want as much of your assets as possible, if you're taking this route, contained within and defined in that revocable living trust. And the primary reason for that, again, goes back up a couple of bullet points to where you want to avoid probate, which will slow the transfer of assets if you were to go through the probate process, and it would make those assets under probate part of the public record. And if you don't want anyone else to know what assets you own that are going to be in question for transfer to someone else, put them in the trust. One might say that after a revocable living trust is completed, if you have done just about everything you can think of, or if you have placed, I should say, just about everything you can think of into a revocable living trust, and anything that isn't in that trust falls into the category we used in the previous slide of those insurance policies, bank accounts, retirement accounts with named beneficiaries, property and assets that are held in joint tenancy with rights of survivorship. If you've done all of that, one could make an argument that you don't need a will at all. Having said that, plan on having what's called a pour over will for assets you may not have anticipated on the day you create this trust that come into your possession in the future and don't enter the trust. Have the contingency to avoid the probate process, to avoid delays in winding up your estate. So what other documents do you need to consider as you approach the end of your days, let alone the disposal of your assets as you deem fit after you have shed your mortal coil? Well, I would argue that first and foremost, your powers of attorney are at the top of the to-do list. We're talking about the statutory durable power of attorney for business issues if you become incapacitated. And for this, you would need a notary to go ahead and to affix their seal after you have signed, and ultimately you are giving an individual, and you can designate a primary, a secondary, a tertiary, depending on whether that individual is a living and capable, whoever is in the primary category, to serve as your statutory durable power of attorney, to go ahead and to provide them with access to everything they need to conduct your financial affairs. That's going to involve making sure that everything that is important for you to take care of, whether it's paying the monthly note and utilities, all the way to managing a business, that this information is available for that person. Again, primary, secondary, tertiary, depending on who is able to step up and serve as that statutory durable POA. That's the acronym that's typically used for power of attorney. The other one, the other power of attorney that matters so much is the statutory medical power of attorney, or medical POA, with what is called a HIPAA release. I mentioned in the first session the federal law that created in the 1990s the Health Insurance Portability and Accountability Act. HIPAA is a way of protecting your privacy. So you're going to need to go ahead and have a release so that whoever you've designated as your primary, and again, if you wish, your secondary, your tertiary, statutory medical POA, power of attorney, has the right to review your health record. So these go together very often. And so don't be surprised if you find them on the same document, or if not, that there is a need to have the HIPAA release added to the pile of papers to sign along with the designation of your medical power of attorney. Ultimately, you don't need this to be notarized, although if you are handling your will with an estate's attorney, you'll be handling almost certainly these powers of attorney documents with that attorney as well, and it certainly can be notarized. But if you are doing this on your own, what you simply need are two qualified witnesses who are adult non-relatives with no conflicts of interest, who can sign after you have signed, designating who is your primary, and if there are, again, are more secondary or tertiary medical powers of attorney, who will make decisions based on your wishes should you become incapacitated, unable to articulate what you would want to see occur in terms of aggressive versus comfort care in certain situations where we are looking at the possible end of life. Now, absent a medical power of attorney, or MPOA, you can see the acronym there on the slide, there is, just like there's intestate law, there's also law about who standard decision makers are, and it goes in a certain relational order. In the absence of an MPOA, the spouse is the person first approached about decision making, then adult children who have to come to consensus, then parents who have to come to consensus, then siblings who have to come to consensus, then other extended relatives who have to come to consensus. If there are any family dynamic issues, and let's face it, where aren't there family dynamic issues within our various extended family structures? This could get really complicated really fast, depending on the personalities involved and the strength of the relationships that they have with you, the individual who needs someone to make decisions on their behalf. So, like a will, like the revocable living trust, we absolutely recommend that with an attorney, if possible, you go ahead and you get both the durable POA and the medical POA concluded. There's also your directive to physicians, which is also known as a living will. And this explains your wishes, not just for the benefit of physicians, mind you, but for the benefit of everyone around you, especially anyone making medical decisions for you based on your designation in the medical power of attorney, or if for some reason you forego it, the decision order tree of relatives. It explains your wishes for end-of-life issues. Again, what to you constitutes appropriate aggressive care, and under what circumstances would you want aggressive care changed to comfort care? Now, for this, again, if you are already taking care of your will and various trust issues, and you're also dealing with various powers of attorney documents with an attorney, this is going to be part of the document pile as well. But if you're doing it on your own, you can certainly go ahead and have this filled out separately. If you get it notarized, well and good. But two qualified witnesses, again, adult, non-relatives, no conflict of interest witnesses, can sign this directive for physicians, this living will. So how in the world do I get this done if I am just exploring this for the first time? You can certainly search on Google, and we want you to educate yourself as widely as possible. But let's give you a few resources, at least based here in the Houston area, as examples, whether you're here in the greater Houston area, elsewhere in Texas, or someplace else altogether. So I'm going to go ahead and bring all of these up so you can see them at once. I mentioned before that you may have familiarity with clinics as opposed to individual attorneys. Well, here in the Houston area, we have the University of Houston Law Center Clinic, which will work sliding scale. And through their clinical legal education program, they will go ahead and set aside dates and times for appointments to talk about drafting, signing, and notarizing the types of documents that we've listed in today's presentation. And they may want to talk with you about other types of documents as you deem appropriate. If you would prefer to go through an attorney, you can consult the Houston Bar Association and its elder law services. Ultimately, you're going to find other cities are going to have their own separate bar associations. There is also a Texas Bar Association. And if you live in another state, city and state bar associations will be in your areas as well. Some examples through the rest of this resource slide of people who HHCI CARES has worked with. They've presented with us, they have worked with us on helping people get through the documentation and signature process that they needed in order to feel secure about their estate and their person. And while we won't necessarily recommend one over the other, what we will say is that anyone we put on our resource list, we have vetted in terms of ethics and competence. And so feel free to consult with any of the people on this list to see whether or not they may be a fit for you. And again, they should be in the position of going ahead and walking you through every single piece that we talked about today, and probably a lot more. There may be other documents that you want to see in your packet of important files, and consulting with an attorney is the best way to go. We don't want to go into nuance too much in what is otherwise a 101 level presentation like the one we're doing today. Having said all of that, if you do have questions, concerns, that we can help you address, from how to speak to an attorney to why do I need everything that you just mentioned, or anything that you just mentioned in this presentation, Seth, feel free to contact either Peggy or me, and we'll be happy to walk through with you as far as individual consultation during the work week. We're here Monday through Friday, and we're happy to chat with you. Also, we are happy to refer you to any other part of the Hope and Healing Center and Institute if it turns out that you may be a good match for their services. Examples include a variety of support groups, primarily recovery type support groups, but we also include grief support groups, caregiver support groups. At this point, the focus for those caregiver support groups is for those whose loved ones are living with Alzheimer's or other forms of dementia or cognitive decline. You will find enormous resources on our website, hhci.org. And if you click around, you'll go ahead and you'll find the links to include all of our support groups, their frequency of meetings. That includes, by the way, grief support groups, which Peggy leads on the second Tuesdays of the month at approximately 5:30, and that's virtually through Zoom. And that I lead typically on the fourth Wednesdays of the month, unless there is a holiday, in which case we'll bump it up to the third Wednesday from noon to 1 in person here at our campus. I'm going to go ahead and stop sharing the screen at this time. And I'm going to, again, remind you that all of these slides and recordings are going to be available to you. And I'm also going to mention as well that ultimately, if you have a clinical need, we have a robust clinical program that focuses on cognitive behavioral therapy, dialectical behavioral therapy, and that ultimately will screen you for appropriateness for services either here in person or can refer you closer to your home. We want everyone out there who is dealing with heightened stress that may even lead to the level of a mental health disorder to get the help they need. And with that in mind, I'll also mention our Hope Line, which is available every day of the week from 5 to 8 p.m. Central Time. The number is on our website, and we encourage you to use it. Consider it a warm line rather than a hotline. If you are in crisis, we want you to dial or text 988 and get the crisis support that you need. So I'm going to take a look at the chat for questions. And a question has come up asking for an explanation again of the difference between community property and separate personal property. Community property is what you share in the marriage and moving forward. Up to the marriage, that is your separate personal property. That is the most general explanation of community property and separate personal property that I'm empowered to give. If you have any questions about whether or not something belongs to you in particular, then you specify in a will that that particular item goes to you, or goes to your spouse, or goes to your child, or if you don't have children together, goes to your spouse's children, or whatever the situation may be. This is where a will goes into as much detail as it needs in order to make sure that an heirloom engagement ring, for example, stays in the family. And so if you who wears that ring dies, it doesn't go ahead and go to the non-related stepchildren unless you have decided that that is going to go to the non-related stepchildren. So that's where you're going to want to talk to an attorney and have an itemized, detailed itemized list of what items are in your possession that you want to make sure go to very specific people or are liquidated and their worth is given to particular organizations. It's a good question. I don't see anything else in the chat at this time. So I'm going to go ahead and say thank you to those of you who have attended today. Thank you to those of you who are watching this recording. You will again get copies of the recording and the slides for all 4 of the Aging with Grace sessions at the end of our series. We will be on again next Monday at 9 a.m. with our third part of the Aging with Grace series. We'll be talking at that time about our understanding living options, aging at home versus long-term care facilities and independent living and so forth. And then the following week, we'll wrap things up by talking about the different ways one pays for aging, wherever your location may be. I hope you have a wonderful week. We very much appreciate you tuning in. And please contact us at hhci.org if you have any questions, anything we can help you with on this level or on the clinical level, the support group level, the grief support level, the caregiver support level. Take care.